Hello students, welcome to my business law lecture series. Today we are going to learn various remedies available to aggrieved party under breach of contract. Let's receive an example. Assume that a contract entered between your family and this person. That this person has to deliver the mail to your family every day and your family has to pay the amount to him. Assume that in one day he fails to serve the mail to your family, but your family already paid the amount to him. In such case, so this person failed to fulfill the terms of contract, and this situation is called as breach of contract, which we have seen in the last class. When a party to contract fails to perform his obligations without a lawful reason. And in today's class, we are going to learn remedies for such breach of contract. Before moving further, let us see some of the terms for remedies for breach of contract. Breach of contract may be committed either by the promisor or by the promisee. Any one of the party can breach the contract or can break the contract. The person responsible for the breach of contract is called defaulter or guilty. In this example, this person is defaulter or guilty who failed to fulfill the terms of contract without a lawful reason. The other person to the contract is called the aggrieved or injured party. So in this example, your family member is considered as aggrieved or injured party who has suffered loss from the breach of contract. Remedies for breach of contract is based on the principle where there is a legal right, there is a legal remedy. To protect the legal rights, we have legal remedies. In case of breach of contract, the aggrieved party has a right to enforce his rights arising from the contract in the court of law. He can file a complaint against guilty or defaulter. Remedies for breach of contract is categorized into two ways. The first set of remedies are provided under Indian Contract Act 1872 and the second set of remedies are provided under Specific Relief Act 1963. So, under Indian Contract Act 1872, the remedies are recession of contract, suit for damages, and suit upon quantum merit. Under Specific Relief Act, the remedies are suit for specific performance and suit for injunction. Let us see these remedies one by one. The first one, recession of the contract. Here, rescission means the cancellation of the original contract by the aggrieved party. So here, cancellation or the termination of contract by the aggrieved party. So there are two situations for rescission of contract. The first one, when the court grant rescission for the contract, and another situation, there are some situations under which court cannot grant rescission or cancellation of contract. If the contract is voidable by the aggrieved party, or when the contract is unlawful and the aggrieved party unaware of it, he innocently become part of such contract. In such situation, the court can grant rescission or cancellation. If aggrieved party expressly or impliedly ratified the contract or renewed the contract, so in such situation, court cannot grant rescission. Or without the fault of either of the party to contract, there is some changes in the circumstances and the parties cannot restore the benefit from the contract. If they cannot restore or return back the benefits from the contract, the court cannot grant rescission. If third party has got some rights from the subject matter of the contract, again, the court cannot grant rescission because the third party is going to face some loss. So, to protect the third party from incurring any loss, the court cannot grant cancellation. Aggrieved party seeks to rescind only part of the contract. If aggrieved party wants to cancel only some portion of the contract and he is ready to continue with another part of the contract. In such situation, the court cannot grant rescission. If they want to cancel the contract, they have to cancel the entire contract and not any part of such contract. In any case, if the court grants rescission of the contract, there will be these three legal effects. The first one, need not perform the contract. If the court provides rescission or cancellation of the contract, the parties to contract cannot continue the contract or need not continue the contract. They are relieved from the rights and obligations of the contract. Liable to restore the benefits they have received from the contract. They have to return back the benefits received from the contract. Entitled to compensation for any damages through the non-fulfillment of the contract. If the court orders or directs for any compensation, then they have to provide such compensation. And the second category or second remedies for breach of contract is suit for damages. So here damages indicates the monetary compensation allowed by the court to the aggrieved party for the loss or injury suffered by him. For the loss suffered by the aggrieved party out of breach of contract, so the court may order for some monetary compensation. In order to make the loss good, the court may order some monetary compensation. So such monetary compensations are called suit for damages. We can classify such damages into four categories: general damages, special damages, vindictive or exemplary damages, and nominal damages. Let us see these damages one by one. General damages is to recover normal or direct loss arising naturally due to breach of contract. If any loss incurred out of breach of contract. So in such situation, if the aggrieved party claim for only the normal loss or the direct loss, so then we are going to call it as general damages. Assume that Mr. Anil wants to sell his bracelet to Mr. Kiran for rupees 2 lakh on 1/1/2020. After some time on on 11/17/2020, assume that the gold price increased and he increased the price of bracelet. So he cancels or he break the original contract and he sells the bracelet for rupees 2,50,000. He break the original contract and he sells the goods for 2,50,000. In such situation, Kiran faced the loss of 50,000 because original contract was for 2 lakh and the second contract is for 2,50,000. So he has suffered a loss of 50,000. If he claims for 50,000 rupees of damage, so we are going to call it as general damages. He is claiming only the normal and direct loss. In such situation, we are going to call it as general damages. And the second one, special damages. So is to recover the special loss. So here, in addition to normal loss, if we incurred any special loss, again, this special loss is due to special circumstances or special situations and which should be known to both the parties to contract. Special damages is for special loss incurred for special circumstances and which should be known to both the parties to contract. Here we can refer the case Handley versus Baxendale 1854. So wherein which we can focus on the term special damages. So here, assume that this is Mr. Handley, owner of flour mill, and this is Mr. Baxendale, owner of a transport company. And this is a case in between Mr. Handley and Mr. Baxendale. Mr. Handley was running a mill, flour mill, so which includes this process of crushing and filtering the flours and all. One day there was a breakage in crankshaft, so the mill was shut down. So this mill includes machinery and a part of machinery considered as crankshaft. So there was a breakage in this crankshaft, and as a result, the mill was shut down. After that, Handleys delivered the shaft to Baxendale to be taken to engineering company. Handley delivered this crankshaft to Baxendale, which should be delivered to engineering works for repair. You should remember that at the time of delivery, Handley haven't disclosed the fact that his factory is closed or locked down till this crankshaft is get repaired. So for that, after that, by some negligence, Baxendale delivery was delayed. He haven't delivered the crankshaft to engineering works. Till then, Handley suffered a loss from lockdown or shutdown of his factory. Then so Handley wants to recover special damages from Baxendale, stating the negligence of Baxendale for shifting the crankshaft to engineering work. He's quoting that Handley suffered loss only because of the negligence. So that is the special circumstances. Apart from shutting down of the factory due to breakage in crankshaft, he is suffering additional loss that is because of Baxendale. Due to his negligence, he is suffering loss. But the court given judgment that court refused to grant special damages under this ground because the circumstances should be known to both the parties at the time of entering into contract. So here, Baxendale was unaware of the fact that Handley's mill will be closed till the crankshaft gets ready. It was unaware of the fact. So on this ground, the court has given judgment in favor of Baxendale rather than in favor of Handley. Baxendale was unaware of the special circumstances. For that reason, Handley cannot demand for special damages from Baxendale. Special damages can be given only when the special circumstances known to both the parties at the time of entering into contract. And the third category of damage is vindictive or exemplary damages. It's for the compensation or loss suffered, but it's with a view to punish the default. Assume that this person promised to marry this lady, but later he taken back his promise. And this situation, so this aggrieved party or lady, if she gone court for vindictive or exemplary damages, the court may grant such damages. Because the court may grant vindictive damages under special two circumstances. The first one in case of marriage and the second one in case of wrongful dishonor of a check. So in both the cases, the court may grant vindictive damages. And the fourth one, nominal damages. So it is not for any specific loss, but it is awarded for technical violation of legal rights. For such things, they cannot award general or actual laws or the special laws. So they are going to award some nominal amount. So we are going to call it as nominal damages. So we have completed recession or cancellation of contract, and second one, suit for damages. And the next one we are going to learn is suit upon quantum merit. So suit upon quantum merit means as much as earned. So here, entitled to recover from the person who has enjoyed the benefit. Aggrieved party can get the benefits from defaulter as much as the benefits that he has received from the contract. The claim for quantum merit arises only in the following circumstances. The first one, when the agreement is discovered to be void, or when it is non-gracious act. So if the contract is for some kindness or some sympathy or to get some favor, we are going to call those categories as gracious contract. But it should be a non-gracious act when there is no agreement as to remuneration. If the contract doesn't contain anything regarding remuneration, when one party abandons or refuses to perform the contract, or when a contract is divisible, when an indivisible contract is performed completely badly. So, in all these situations, one can claim for quantum merit. Assume this a lady entered a contract with an interior designer. After some time, so this interior designer comes to know that so this lady haven't title over the home. She is not the true owner of this home. In such situation, the contract discovered to be void. And in such circumstances, so this interior designer already invested some amount for designing work. And this person is an aggrieved party or uh, uh, incurred loss, and he has all the rights to recover the benefits from this defaulter. So he can recover the amount from this lady as much as the benefits that she has earned or she has gained from the contract. So that is considered as quantum merit. So we have completed all the three categories of remedies provided under Indian Contract Act 1872, and we have to complete one more set of remedies provided under Specific Relief Act 1963, that is suit for specific performance and suit for injunction. So suit for specific performance. So here assume that this lady entered a contract with a person for marriage, and later this contract was broke down. In such situation, the court may order for specific performance. That means specific performance means actual performance of the contract by the party in default. So original contract's purpose to be performed by the defaulter. When damages is not adequate remedy for the loss, court may direct for specific performances. If we cannot measure the actual loss, or if money is not the adequate measure, in that situation the court may order for specific performance of the contract. So specific performance indicates the actual performance of the original contract. Under these three situations, the court directs for specific performance. Compensation is in money is not adequate, or if when there is no standard for measuring actual damages, or when monetary compensation cannot be secured for non-performance. Under these three situations, the court may direct for specific performance. And under these situations, the court doesn't direct or specific performance. When monetary compensation is adequate, or when the contract is uncertain, or when the contract is revocable, or when the contract is personal by nature, or when it is agreement is not enforceable, when the contract supervision of actual performance is not possible, or contract is made by trustees in breach of contract, or when the subject matter of the contract is ceases to exist. Under these situations, the court cannot direct for specific performances. And the last remedy is suit for injunction. Is it the injunction that we are talking now? No. So here, injunction is an order of the court restraining a party from doing a particular act which he promised not to do, which restrains or stops from doing an activity which he promised to do. So which stops other party to continue with the contract, we can claim for injunction. There are two categories of injunction. One is temporary injunction and another one perpetual injunction. Temporary injunction will stop the person for doing an activity till the right of aggrieved party is settled. And in case of perpetual injunction, it's the injunction restrains the defaulter permanently from doing an act. He cannot continue with the contract at any cost. But in case of temporary injunction, if the rights of defaulter is settled, or if the rights of aggrieved party is settled, so they can move with the contract. Assume that so Mr. Arun intended to sell his property to Mr. Kiran, but he is not the sole owner of this house property. So he is sharing the ownership with Mr. Varun. In that situation, Varun can bring order of injunction from court stating that so Mr. Arun cannot sell this house property to Mr. Kiran until this aggrieved party's rights are settled in the court. If the court settled the rights of Varun, then Arun can continue with the contract with the Kiran, that he can sell the house property only after the settlement of aggrieved party or injured party. So that is considered for temporary injunction. So if it is perpetual injunction, in such situation, Arun cannot sell this house property. So that is regarding injunction. So which is an order of court restraining a party for doing an activity. So in today's class, we have learned remedies for breach of contract, which is provided under two different headings. The first set of remedies are provided under Indian Contract Act, and the second set are provided under Specific Relief Act. So here, recession or cancellation of contract, suit for damages, suit upon quantum merit, and here we studied specific performance as well as injunction. Just see some questions here to check your understanding. Cancellation of original contract by the aggrieved party is called option A, recession of contract, option B, suit for damages, option C, suit upon quantum merit, and option D, all of the above. Hope you are able to guess the answer. That is answer A, recession of the contract. Under the following situation, court can grant rescission. Option A, voidable by the aggrieved party, unlawful contract and aggrieved party unaware of it. aggrieved party expressly or impliedly ratified the contract, and option D, none of the above. And the answer is C, aggrieved party expressly or impliedly ratified the contract. In the first two situations, voidable by the aggrieved party or unlawful contract and aggrieved party unaware of it. Under both the situation, the court can grant a rescission, but only under the third option, the court cannot grant rescission. Legal effects of rescission of the contract is or need not perform the contract, liable to restore the benefits, entitled to compensation for any damages. And the option D, all of the above. Hope you have already guessed the answer, that is D, all of the above. So legal effects of the rescission contains all the three. Recovering normal loss, direct loss arising naturally due to breach of contract is called normal damages, special damages, vindictive damages, or exemplary damages. So it is normal damages. Give the proper term for as much as earned in remedies for breach of contract. Suit upon quantum merit, general damages, special damages, vindictive damages. Of course, the answer is A, suit upon quantum merit. These are all the references that you can go further and learn many things here. Thank you for watching and happy learning.